Okay. Yeah, thank you. Today we invite Kathy Zhang, very busy lawyer, but come to our office to support us to talk about land title, how to review title registration. Yeah, thank you.
Thank you, Vivian. Very happy to be here. Good afternoon, everyone. My voice is okay, or I need to speak louder?
Voice okay? Online people.
Frank， 你听得到吗？
Knock your head.
挺好的，可以，没问题。
Okay, awesome. Okay, yeah. Thank Vivian to invite me to be here today. I'll briefly talk about some basic concepts related to land titles. But meanwhile, because we have a relatively smaller group, if everyone has any questions you want to ask, I'm happy to answer. But it's up to Vivian. If you have specific rules, you want them to just ask questions at the end of the presentation, that's fine by me.
Sure.
Okay. Yeah, without further ado, let's get started. So today, we're gonna focus on land title registrations. Some of my realtor friends also asked me those questions before, like when they represent a client. They normally want to take a look at the title, see if there are any concerns before they put an offer on the property. So I think it's actually necessary to have this today's workshop, as we can have a little better understanding of what those registrations are and what you can do for your clients. Before there's some housekeeping, I guess. So first, just introduce a bit myself and my firm. My name is Kathy. So not currently, my firm is J Sunrise Law. It used to be Kathy Zhang Law Firm. So we have special services because most of our lawyers can speak Chinese. There's some they don't. So if you have a client they speaking Mandarin Chinese or Cantonese Chinese, we're very happy to assist them. So yeah, so in this slide there are 4 lawyers, so they all working for J Sunrise Law. So we are a team of lawyers, not only myself. Before we start this discussion, I just want to quickly briefly.
Change slide?
Oh, gee, thank you. That's the problem. So this here to say the firm J Sunrise Law used to be called Kathy Zhang Law Firm. I started this law firm, but now we have 4 lawyers. We provide legal services both in English and Chinese. Most of the lawyers can speak Chinese. As you can see, Ross doesn't speak Chinese. So we have lawyers speaking Chinese, Mandarin Chinese and Cantonese Chinese. So before we start today's topic, just housekeeping. Just remind everybody today's discussion is just me providing some basic legal information. There's no legal advice provided, and nobody in the room is my client. Let's start today's topic. So before we talk about all the registrations, I'll just have a very brief introduction about the land title system in Alberta. So we call the system here in the province a torrent system. It is in the legislation called the Land Titles Act, which we don't have to understand the history of it. We just need to remember that a land title in Alberta is a proof of ownership of property. Each title has a unique link number. So as long as you have the title certificate and you can see someone on title, you can assume that person is this property's owner. And there's a lot of important information on land titles. A land title certificate. So this is what we're gonna focus on today. So this document.
Maybe that Eric.
Yeah,
Sean.
maybe you can help.
I
Thank you so much. Yeah,
And,
I keep forgetting. My computer is not connected.
if I can see your screen, so I can.
Yeah. Do you want to?
Sean, do you
I
mind
can see- I can see over
chair
there.
in one
Yeah.
chair?
Do you mind if I see over there? Yeah,
Sure.
the broadcast.
Okay. Oh, you can.
Sure.
And you can. Yeah.
Oh, sure,
Once if you're off the chair.
Okay, sure.
Here's the one, so I can see your screen.
And then I'll. Which slide up? Okay.
Let's swap that.
Yes. Okay, so now we talk about title certificate. Land title certificate is a document that serves as evidence of the ownership of a property. The land title registry can provide valuable information about a property, such as the owner's name, the property legal description. So I have an example of a title certificate. For a very experienced realtor, you've seen this so many times. But for someone new, I think still necessary to show how it looks like. So this is a title certificate. Of course, I have to hide all the information. It's my client's title certificate. So as you can see, oh yeah, So as you can see, I can just stand up here a bit. Yeah. So there is a link number. So here, so that's the identity of the property. And under this legal description, there's also a plan number, unit number. Those are also how you can identify the parcel. And then here says state fee simple. So that's the ownership. I will talk about that later. And then there will be owners here.
Can I just interrupt with question or you
Yeah.
prefer? So
Yeah.
if the title parking, because this looks as condo,
Yeah.
where we can confirm this a title parking?
If you wanna know, let me think. Because I think the order is a bit awkward because we received the documents after you already have a
Okay.
unconditional offer. So
Yeah.
everything is already in the contract.
Yeah.
But as a realtor, I think it's probably no harm to contact the condo company, the management company or condo board to confirm if they have a title parking or not.
Mhm.
Maybe can find out that in the condo documents when before condition day, you need to review all the condo documents. It should be in there, I think. Yeah, okay. Okay, yeah, I think it's good to ask questions when you have, don't feel bad to interrupt, because I sometimes don't know if you have some questions on certain things.
Mhm.
Okay, so, can you go down a bit lower? Yeah, so here just owners, and then it shows joint tenants. This we'll also talk about shortly. So just wanna show people how a title certificate looks like. So on the other side, it's oh, no, sorry, I think there's more oh, yes, here, second page. So those are the registrations. You can see the different names, restricted covenant, utility right of way agreement, mortgage. So those are the things we're gonna focus today, and we can talk about in more details later. I think that this is pretty much about the slide. And we go to the next one. Okay, so from that title certificate, you can see the ownership type is fee simple. So we have a, oh, yeah, sorry, I don't know, there's something wrong with the. Yeah, okay, yeah, it just maybe, I don't know. Okay, but as long as you can see, yeah, so there's three types of title ownership in Canada in general, not only in this province. Fee simple is the most common one. It's also the most comprehensive one, which means the owner has full control over the land and the building. Owners can sell, lease, enter into any other legal agreements regarding this property. So this one is only limited by public rights and local laws, such as zoning restrictions. And the second one is a leasehold. Leasehold, we'll think about rental property. So that's leasehold. Commonly seen, I think I closed some deals, they are leasehold properties. A typical one, I think, is, for example, in Banff National Park, you will not have a fee simple title. You will have a lease with the national park, 50 years lease. And also some properties, I think, around the University of Calgary, some properties, they have a 99 years lease, I think. So those are leasehold property, which means you don't have full ownership. So you have a right to occupy this property for a number of years based on the lease agreement.
How about the mobile home? So mobile home is one of the least.
Mobile home is not really related to land. I guess that's just, it's a personal property. Yeah, but there's some special rules we can talk about, I guess, in maybe a separate session. Yeah, so mobile home is asset. Yeah, it's not land. So today we'll talk about real property, which is land involved and the building about on the land. So the third one is a life estate. So this person can occupy the property as long as this person is still alive. This typical is dower rights. So someone married to someone, if the spouse dies, the other person can live on that property for the rest of his or her life. So that's life estate.
How about like prime minister? Do they like if like 美国
Yeah.
US?
Yeah.
The president can live in the White House. Is that called life estate?
Well, I don't know, I haven't really actually read anything, but I can get back to you. I can do some research on that. Okay. And next one. Okay, next one is about the details of the owners. If you remember on the title certificate, it shows the two owners are joint tenants. So there are two types of owners. One is a joint tenants. The other one is tenants in common. The joint tenants is a form of ownership by two or more people. Each person owns an equal share of the property. The key feature of this joint tenancy is the right of a survivorship. So it means one person dies, the other person will take over the whole property. And the other one's tenancy in common. This one similar is to joint tenancy. They allow two or more people to hold title together. But however, there's no survivorship, which means if one of the owners dies, his portion will only be distributed to his beneficiaries. So that's the difference. So I put some wording here just to avoid confusion, because when you review a title certificate, you will not see a title certificate shows tenants in common. They don't say that. So when land titles register tenants in common, they have a special requirement on the wording. So if you see something like here I listed, says someone adds to undivided certain percentage of ownership. So that means it's a tenants in common. You will not see tenants in common. You will see description like this. So that's something you can keep in mind.
So it's not necessary like
Yeah.
couple. No, I know majority couple is joint tenants,
Mhm.
but they can also register as tenants in common.
Yes. Yeah, so when the deal goes to a lawyer, so that's one of the first questions a lawyer will ask a client. What do you want? Are you two joint tenants? Do you want survivorship? Or you just want to have a tenancy in common? Because some couples, especially let's for example, blended families, second marriage, they have their own children, they have a very complicated situations. So they prefer their money goes to their own children. So in that case, they want to have a tenancy in common. Because joint tenants is one person dies, everything goes to the wife or husband, right? So that's what they try to avoid. So even couples, they might have a tenancy in common.
So dower rights only apply for joint tenants, not apply in tenancy in common.
No, dower rights is something different. If both people on title, either of them, they have the right to live there. Doesn't matter that person dies or not, right? Because that person is a registered owner. Dower rights only applies to only one person on title, but this person is a married person. Even the spouse is not on title, or based on Family Property Act, say they're not divorced, they still couple, as long as but by law, this property is not family property. This property was purchased by a husband and then they got married. So if they get a divorce, this property will go to the husband. But before they get a divorce, as long as they are married couple, the wife has a right to live there forever until she dies. So that's dower right. Dower right only applies to there only one person on title.
One person.
Yeah.
So
A married
another,
couple. one
sorry,
person.
another question.
Yes.
For example, if a
Yeah.
customer said they worry about their son will marry soon,
Mm.
they worry if they divorce, their house will be divided into half.
Yeah.
Can we suggest say maybe to tenancy common and the parents
Mhm.
in, and then the spouse
Yeah.
won't have
they-
dower right?
So they wanna buy a house with the parents and they put the parents
Like-
on title as well?
Yeah, is that a way to prevent in the future if the young couple
Mhm.
separate, then
Mhm.
the other party can take a half or as a dower right?
Yeah, so family law, Family Property Act says certain things are exempt from division. For example, someone bought a house before marriage, so that's exempt property. Even say they get divorced in the future, that's not divisible, so they
But-
cannot get it.
But if the other parties
Yeah.
stay one night or couple night, they they have dowry rights, right?
Yeah, dowry right only means when they still married, the other person has the right to live here. But once they finalize the divorce, that property, he or she has no right in this property, except the value increase. Say this husband bought a house before the marriage, and then later they got a divorce. The husband will get to keep this property. But during marriage, if the house became more expensive, the increased portion potentially could be 50-50. But the wife cannot sue for the house. The wife can sue for the value increase, maybe 50%. The law doesn't say 50%, says equitable. So as long as it's fair. So it could be short marriage, could be the wife didn't make any contribution. So maybe the wife will only get 20%. So that part we don't know. Yeah, the judge gonna have a say on that. Okay. John, yeah, so this is joint tenancy. So I put it here. Can you tell your portion, or can you sell your portion to a third party? Because based on the definition, it here says each tenant, we'll talk about tenants in common. So each tenant in common can own a different percentage of a property and can dispose of their share independently. So this is the definition is a bit confusing because people might think, oh, okay, I have 50% as a tenants in common. So I can sell my portion to whoever when I need the money. Because some of my realtor friends actually asked me that question.
Yeah.
Someone want to sell 50% and ask the realtor if the realtor can represent them. Yeah, so the answer I think is a yes and no.
Yes.
So we go to the next slide.
We see couple listing, foreclosure listing and sell portion.
Yeah, so that's why I said the answer is a yes and no. I say yes. I say
I think
yes.
it's a legal
is-
matter, right?
Yeah.
They should deal with the.
Yeah, so can you sell your 50% if you own some property with another person and you are joint tenants 50-50 or 30-70, doesn't matter. Can you sell your portion to someone without the other person's consent?
Do they
because-
get evaluation like for the property first? That's how they do it.
Yeah, so that part is different issue. So now we say we agree on the value, but the other party doesn't want you to sell, or that person doesn't know you want to sell. Can you sell without the other person's consent? So because the definition says you own 50% separately from the other person, right? That's your property, you can sell. So the answer is yes and a no. Next slide. Oh yeah, this one. So as you can see, co-owner, I didn't put the definition of a co-owner, but it's actually include tenants in common. So they are co-owners of a property. So this is a law of a property act in our province. It's a legislation. So it says, as co-owner, you can sell your portion, but you have to apply to court for an order terminating the ownership first. So which just means if you want to sell your portion, you need to get a court order. Otherwise, you sign a purchase contract and on the closing day, you have a transfer document signed only by one of the owners. The land titles will not do the title transfer for you. So you can't close the deal. So if someone want to sell their 50%, you have to let them know. They probably need to talk to a lawyer, see if they actually can do it. By law, they have the right to dispose their own property, but there are certain things they have to follow. Pretty much this one, they have to get a court order. Tenancy in common, when they ask you to sell, yeah, they have to go to court.
But we
Yeah.
see lots of like
Yeah,
divorce.
Yes.
Couple.
Yeah.
Husband or wife
Mhm.
sell their portion.
Yeah.
Can they originally register as a tenancy,
tenancy in common,
joint tenants?
joint tenants.
And
Yeah.
then they change to tenancy in common and then apply this?
So that one, some people, yes, they can agree to change to tenancy in common. I mean, that's good. But mainly it's just by law. Because once the parties are separated by default, joint tenants will automatically become tenants in common.
Oh.
Yeah, because the survivorship will be gone. Because the parties are separated, husband and wife,
Oh.
the law doesn't protect that survivorship. As long as they can prove that they actually separated. It's in the same legislation, Law of the Property Act. I didn't cite it today, but
So it's
if you
default
go
if they divorce.
separated.
or
Say the
separate.
couple have a house together, says as joint tenants.
Joint tenants.
So if husband or wife dies, the other person will have the whole house. But if they are separated and in a divorce proceeding, if they can prove separation, that will become tenants in common. Say they haven't divorced, but they separated, and the land title certificate shows joint tenants, and then one person dies without a will. Even with a will, yeah, because that's a without a will. Yeah, so if they are not separated, the surviving person will get the whole house.
Yes.
But if they are separated, that surviving person will only get 50%. The other 50% will, based on Wills and Succession Act, a different legislation, see who is the legal beneficiary, who can get the other half.
So the definition of the separation is if they didn't sign anything, but you just prove they live in different house for over.
The separation is also defined under Divorce Act, so they have to meet certain requirements. Yeah, number one is they have to live separately, but could be in the same house, different rooms, and not as couple. And at least one person needs to communicate to the other person, I want to get a divorce. I don't want to be with you anymore. Not because I got a job, I have to go to one court for 3 years. And then financially, they kind of stop helping each other. They are not acting as an entity together, or they don't go on vacations together, everything's separated. If they can prove that, that's separation. They don't have to have a formal separation agreement. So that's very complicated. If they have a divorce dispute, so some of those issues, yeah, they're gonna fight about because it's money involved. Okay, so I guess we can go to the next slide. So this one just try to remind everyone, if someone want to sell their portion, they say, well, tenants in common, I have a 50% I can sell. Keep in mind, they have to go to court. Yeah. You can still represent them. Just say, we have to make sure you will go to court, get this order before the closing day, right? Otherwise, the land titles office will reject this.
I
title
still
transfer.
have a question. Can you go back to the last one? If they
Yeah.
go to the court and
Yeah.
apply for termination of co-ownership,
yeah.
then will they lose the right or lose the?
No, the
50%?
court will order based on their application, right? Some they gonna, it depends on what they want. If it's like 2 houses but on the same parcel, maybe the court will do a physical division to say, okay, you have this house, you have all duplex, right? But if not, that the court can order, say, A, sell your property, sell this portion, and then you get the money, and there is new owner. Or the court might say, just sell, both you guys have to sell, and then you just divide the sale proceeds. So that depends on the application and also if the order is reasonable and fair. Okay. Yeah, so we don't know the result. It depends on what they want. Okay. Next slide, please. Thank you. Okay, so now we can talk about the real residential resale property purchase contract, because we talk about how to review a title certificate before you represent the client to put an offer on property. So everything we do as a realtor, actually according to the standard contract form. So I just put the relevant provisions here. So the first one is paragraph 5, land title. So this one talk about when you help client buy property, which kind of title means clean title, because when they buy the house, they don't want to have any trouble. They don't want to buy trouble, right? They don't want to buy legal issues or legal disputes. They want clear title. So the definition of a clear title is actually here. So this title can have some stuff on the title certificate. We call them registrations or registrations, instruments, or to next one. Okay, so not next, sorry. I just mean like I'll talk about the definition next. Encumbrances. So 3 items. Number 1 is as long as the law permits the registrations to be on title, it's okay. And number 2 is the non-financial obligations can still remain on title after closing. And here the standard contract form listed what is non-financial obligation, easements, utility rights of way, covenants, and some other things. And then, sorry, the number, this is a sub paragraph B and C. C is homeowner association caveats, which means that property has a HOA fees. And then the last one is the buyer agreed to assume. For example, it's a rental property. The lease is registered on title, but the buyer will take over the lease. So the buyer is okay to have that lease interest still remain on title. So that's the requirement by the contract. And there's the next slide, please. So the next one is section, is a paragraph 6.1. This one is not about title, it's about seller's representations. So in this one, this is also related to real property report. So this one just saying the seller represents the location of the buildings and the land improvements. It's on the land and not on any other things unpermitted, unless there is a register agreement on title. So this is commonly we call encroachment agreement. So when you review a title, there is agreement called an encroachment agreement. That's okay. So this is also a paragraph in that contract showing a registration. This is just wanna show you what is relevant in
So
the contract.
for the encroachment agreement,
Yeah.
if the previous owners agree with the neighbor
Mhm.
and sign.
Yeah.
So the next, the future buyer owner
Yeah.
cannot change it.
Yeah, it runs with the land.
Mhm.
Yeah, you can't really change. You can, but you have to have some legal grounds. You have to go back to the legislation and you have to make an application in court. Yeah, or if the parties agree to change it, I think it's okay. Because it's agreement. Yeah, and if, just for example, if you sign with the city, right? Because some encroachments onto city property, and then city agree to sign a encroachment agreement. So the standard one, they always say you have to maintain it, right? Fix it if there's something wrong. So if you decided to remove it or if you're gonna change it, you probably need to talk to the city and change the agreement, or you can remove the whole thing and make it just complying. And then the city might just agree, both parties sign and can discharge that
So
registration.
is that really hard to change? Because I know a part of
Yeah.
West Hillhurst.
Yeah.
There are two zones, but they're not allowed to build to
Yeah.
infill.
Hmm,
Because long time ago, they
Yeah.
raised no
right.
rebuild. So
Yeah.
never change.
Yeah, certain things if you wanna remove, yeah, you have to meet some legal tests or some requirements.
Yeah.
And for public interest reason, probably it's hard.
So
Yeah,
how
it's
about,
case by case.
for example, like April 22nd, the city will probably hearing about changing the zoning.
Oh,
Will
right.
that part still
Yeah,
based on the land title, that street, that area still cannot
mhm.
rezone or they will rezone?
Yeah, that will also have to look at the other legislation, like, authorizing the city to do certain things, right? If it's within their discretion and they reach agreement, the law cannot really do anything about it. It's within their authority, right? So it depends. But if their decision is unreasonable against public policy, against some other important things, if one interested party wanna actually deal with it, can bring application, judicial review application in court, right? The court, because the court always has right to look at legislation and decide if this is reasonable or not, and if it's against constitution or against like higher level legislation, and maybe the court can say, okay, you can't do this. There's always battles, I mean, in court, right? Like provincial government and all those things we always heard on news. Yeah, so it's always case by case. See if you can prove the court it's actually good to remove that.
Quick question.
Yeah.
So when we pull the title, on the title it says there's a restriction, but it never shows the detail. You only get some case file.
Yeah.
File number, right?
Yes.
So in order to know the actual restriction on title, you actually have to pay
$10.
another $10.
Yes, to
For
get
the
it.
case file.
Yes,
Me too.
yes.
Yeah.
Yes.
Has a way for free.
Yeah, so that one, I think I will mention later in the slides. I think some of the slides. I think it depends, because if you look at paragraph 5 of the contract, it says if it's an easement or restricted covenants, those are allowed to remain on title. But the same time, you wanna make your clients happy, you want them to buy, the property they really want. There's certain restrictions they might not like, right? If you don't pull it out, you don't know, and later they realize, oh, I'm not allowed to do this, to do that, in this, I don't want this property anymore, but then it's too late. So I guess it's always, I think it's always good to just pull it and show the client which kind of restrictions on there, right? Yeah.
Is it the restriction also show in the RPR, the report?
RPR show
It's also shown.
certain things. Utility rights of way.
Yeah.
Yes. Yeah.
It will show.
Yeah. So if there is utility right of way registered on title, it probably means if especially it shows by city vocabulary, right? So that means there's certain spots on your property you're not allowed to build anything permanent structures, and then those will show on RPR. You can see utility right of way.
That means they
which
will
portion.
match with the land title. Right?
Yes.
Okay.
Yeah.
Yeah, I have another question about the encroachment agreement. So
Yeah.
if we found that registered under the title,
Mm.
so that means the RPR has to show that as well or no?
Most will show, but because it's been so many years and they have new teams and always have new rules. So in the past, we saw some they just voided, and then there's an encroachment agreement, and some they have different steps. But so that's why if you see an encroachment agreement on title,
Always check
also
RPR.
maybe also put it out and see, right? Because in that instrument you will see RPR, see if that's the current one. Yeah, I think that's the way how, or email the encroachment department at City Tower, ask them if there's any questions. Yeah, okay. Okay, so here just a little breakdown, it's just paragraph 5, talk about 3 situations. Yeah, so the last one, I don't think we need to talk about the clients agree to assume. So the third, oh, sorry. So I just went back to.
Oh, back to-
Yes, yeah, just here, so yeah, I wanna just break down a little bit, it's C, sorry, it's a typo. A, B, C, 3 situations. So I put some more information here, so we can go back to this one, those in. Yeah, so the first one is implied by law. Yeah. Okay, so I listed all the situations in legislation. I don't think I need to read everything, but you can just keep in mind, those. Number one important commonly seen is the tax notification. Someone didn't pay property taxes, and then you will see a tax notification on title. So that is implied by law. Sometimes they all say the property taxes and it hasn't been registered. It's still something allowed. It will affect title. So that owning taxes, that's one. And then right of way easements, some private between neighbors, between people on the neighborhood, but some just with the government. So those are the ones implied by law. So as long as the law says, yeah, you're not allowed to do this, and then register on the properties, that will remain. It doesn't matter you agree or not. So those are implied by law. If you want to know the details, you can always go check the Land Titles Act and section 61 and see listed all the registrations implied by law. So that's contract subparagraph A, and B is here. Is next slide. Okay. Let me see. Yeah, so I listed implied by law. So the next one, I didn't list because the second one, the contract term already listed what they are. So I just put everything together. So I want to say when a lawyer receive a contract, we need to look at the title certificate. Then we put those registrations into 2 categories. One is permitted registrations, the other one non-permitted registrations. Some of them under the category implied by law, some under the second one, the non-financial obligations, and then some HOA fees. Some may be assumed by the buyer based on the contract terms. So here I just put into 2 categories, permitted and the non-permitted registrations. So when you look at a title certificate, you can have a brief idea if this is permitted or not. Permitted means after closing, that registration will be still on title. We run with the land, doesn't matter who is the owner. The non-permitted means after closing, the seller need to use the money to pay off or do something to discharge that registration. That registration should be gone once you have a new owner on it. So that's probably the most important one, because that's why you need to look at the title certificate and tell your client the risks, right? So the first one is permitted. I listed those ones: utility rights of way easements, restrictive covenants, homeowner association, encumbrances, encroachment agreements, zoning regulations, development agreements, party wall agreements. And here I'll try to quickly explain a little bit of each single one. So easement is a right for someone other than the property owner to use the property for a specific purpose. Oh, sorry.
It's different document.
Yeah, I keep forgetting to.
It's blank.
Oh, it doesn't show there. Okay, what can we do? So the phone probably because formatting or for some
The
reason.
loading.
You think it's because of loading?
It's fully open. It's also blank.
Oh,
We open and try.
So
yeah, because I emailed to.
if you project
It
from
might
your
be-
computer,
Yeah,
you
well,
can
I-
still read it.
Yes, but we just don't have a HDMI cable. How can I?
Okay.
Yeah, I think, yeah, I forgot about that.
Let's try the email again. Email again,
You think it's the,
the file that damaged during.
you think so? Okay, I can try. Oh, I have to email on my phone because
Oh, okay.
there's no,
Let's leave it.
there's no
That's okay.
internet connection,
not-
the computer. Okay, I can. Let me see if I can see them. Also can't, it's a formatting issue if you,
Did you, Janessa, did you bring your computer?
yeah.
Use his computer. You
Yeah.
can project, right?
Yes,
Can
you connect
Yeah,
last.
yeah,
I
Yeah.
think
yeah. I sent to you.
maybe not on this TV.
Sure. Take a break.
Itself.
Drink some water.
Do you have a
Yeah.
browser or something?
I think it's a format.
Or-
It even shows on cell phone, maybe it's like, if
Or-
it's a cell phone.
Or can we
We
convert
have
to
a cable
PDF?
here now.
Oh,
Can we save
yeah,
it to
sure.
PDF? And
Okay.
Let's save it.
Oh, yes, I can just convert to PDF, maybe that's easier. I'll print it as a PDF and then send to you. I'll, next time I'll remember to bring an HDMI cable. I do have that in my office. We just print it into PDF
Sure.
and then maybe,
Okay.
right, and see,
Email
easy
that.
to share, right?
Email that. Yeah.
Yeah, so that would be okay. Yeah, there's everything done. Okay, I'll email the PDF. Okay, but I
Or
have to-
you want to
Or
email
email
to
to you.
You
And
can
you
put
can
your
say
email on
something.
her.
One
Just
second.
Map.
Okay, I need to. Okay, I can.
Your battery is not.
Okay, I have to email this. Now my phone's connected.
Oh, this is fake.
It's about just.
I can't remember the email
The
address.
email.
I sent.
Oh, you can send to Jeff.
Can you give an email?
Sure,
The other ones.
Yeah.
But then you have
You
to
can-
let me know how to spell your name. I don't know your name.
You can type B A
A
U U
U U
D at iCloud.com.
at iCloud.
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 Oh, iCloud. Okay. iCloud.com. BAAUUD
Yeah.
at
Okay. Is your
CG got it. And still sending. Okay, I think it's sent. CG got it.
yeah, it's not. Just
Give to me.
you can have this. You can have this. And then,
I'll use that one.
yeah, you know.
Okay. I can move to the corner.
Is your specialization in property law?
I started Yeah,
started
with the real property law. I've done that for many years, and now I have another associate doing this. So I can have time to also work on other things. Because I also like litigation work, so I also have a commercial litigation practice. But
What is your
this is still
specialization?
something I'm good at. Yeah, because I've done that so many years. But we have another lawyer helping me.
Mhm.
Yeah. Okay, that's perfect. So I guess I can control this myself. Okay, so how to use
Just use the bottom or to make it. Or yeah, both means.
Oh, okay, maybe we'll go to the previous one. Yeah, so we were talking about all the registrations will be divided into permitted and non-permitted. So on the closing day, the lawyers will deal with the non-permitted, make sure the seller's lawyer will work on the non-permitted these registrations to decharge them. So I listed all, so now here we listed all the permitted registrations. But when you look at a title, a new title, maybe check out those, see if they are on title, 99%, you don't have to deal with them. But as we said before condition day, if you want to know which kind of restrictions on this property, you probably still need to pull out to especially easements and restrictive covenants. You probably want to look at what they are about. And then next one here, I have some definitions to help you understand, remember what are those things about. So easement is a right for someone other than the property owner to use the property for a specific purpose. Commonly, we see access to another property. Like say you buy a house, there's an easement registered on title, and if there is a park nearby, so there might be an easement saying even the path to the park is your property, but everybody can walk on it. So that's easement. And then utility right of way.
Do they normally pay rent?
No,
No?
it's
They still need to shovel?
it's like just I think it's designed to be fair. Like this property can only be used by you have to use the neighboring land to be able to use your own. So you have to provide access. So the other type of easement is underground because in property law, when you buy a piece of land, you own not only the surface, you also own underground and above air. But there are some limitations like mineral rights and those things. So if your neighbor utility lines need to connect to the cities, they might have to go through under your property. So sometimes you see easements, but you don't see your neighbor need to walk in your backyard or something. But that means maybe there are some pipes under your ground connecting to the city facilities from your neighbor's land. So that's easement. Utility right of way, you can see some showing just registered by City of Calgary, some by maybe INEX, some gas companies. So those are implied by law actually, by legislation. You cannot really discharge them. And then like you, sorry, I forgot your name. So I also, as you mentioned, those will show on real property report, showing utility right of way means the city, if they need to fix something, they have to probably, your property might be affected. They might have to dig a big hole to fix like a pipeline or some utility, gas or electricities. But you cannot stop them from doing that because they have to use your land. So that's why they have this right of way, means you're not allowed to build any permanent structure there. Otherwise, they can't dig a hole there anymore, right? So those are the things you can't really discharge. And then when you close the deal, the client will have RPR. The client can see where they're not allowed to build any permanent structure. That's why RPR is important. So the third one, the restricted covenant. So this one is, they are restrictions placed on the property that limit how the property can be used. So this one, yeah, commonly we see is how they build the property. Like say, are you allowed to build a separate garage there? Are you allowed to convert the single house to a shopping center? Are you allowed to build this house right close to the property line? So do you need to leave some space? So those are the things will be included in this instrument. I keep forgetting I have to use my fingers here. Okay. Okay, so continue. The next one is encroachment agreement. So that agreement allows a structure from a neighboring property to intrude or overhang another property. So we also sometimes see, eaves overing the other property, or just something, the retaining wall, probably very common, you can see. But if the neighbors, they agree, your stuff is on my property, but I'm okay with it, so they sign agreement, register on title, and then whoever owns the neighboring lands, even the future new owners, new buyers, they cannot come back to sue you, say, okay, remove it, because the agreement already registered on title. And then HOA fees, I don't think I
Can we
need to say
change that?
anything about it.
Can we change that?
Encroachment agreement,
Yeah.
it's agreement. I think if the both parties consent, or if there are certain conditions in the agreement saying this agreement expires, or you breach some of the terms, probably you can change it or you can discharge it. Yeah, so I think it's case by case. Have to look at some encroachment from the city, not from the neighbor. So the terms could be different. Yeah, so I have to look at, but as a
sometimes it
realtor,
break the deal, yeah.
yeah,
The house, I mean,
Mhm.
this example is,
Yeah.
long time ago, the neighbor agreed, the other neighbor can drive
Yes.
through their land to
Mhm.
park.
Yeah.
But the new owner doesn't want it,
Mhm.
but because the encroachment agreement, they have to let them go through their land,
That they cannot do anything, right?
because agreement, yeah.
Yeah, so it's very hard to challenge or discharge them. So if someone wanna buy, but ask the realtor to do important things, like, you have to promise this can be dealt with before closing, just don't agree, just say either they go talk to a lawyer or maybe look at some other properties, yeah.
The encroachment agreement can be changed, depends on what kind of structure it is.
Yeah.
Like the house I just sold in Capitol Hill, they have a registered encroachment agreement on title. It's all about the raised up planter
Mm.
encroached into the next, it's a driveway which belongs to the city. So in the future, if this land has been totally redeveloped, let's say they tear the old house down and build a new structure, a new infill, that encroachment agreement will be discharged.
Okay.
There's no,
Yeah. Yeah.
no such thing.
Because
Yeah.
when they construct a new one, they have to go.
Yeah,
to
to
city
see,
and-
They
Yeah.
have to
Permits and all that.
totally remove that.
yeah, because you look
structure.
at the encroachment from the city, it's a standard contract. It says, as long as you maintain, repair the existing one, this agreement is valid, right? If this whole thing is gone, you don't even have a subject for this agreement. So in
Because
that
remember,
situation, you probably can
it
discharge.
says a structure. So a
Mhm.
structure can be changed as long as
Mhm.
the land users, building is all gone or
Yeah.
it removed.
I
it
just
can
need
be
to
charged.
keep in mind, the discharge process, there might be, some time, the lawyers need to work on it, and the clients are okay with that, so those are the things maybe just tell them you need to go ask the lawyer if they can do it, because you might need to get the city consent if you wanna have a quick discharge, right? Because if agreement you wanna discharge agreement, you need to have both parties consent. Otherwise, if one party wanna discharge, the other party disagree, you gotta go to court to argue, right? There's no sense to have this there, so that will take longer.
What's the difference between encroachment and easement?
Easement is access to something. Easement is your property, but either your neighbor or not necessarily your neighbor, someone nearby, without using some of your property, they cannot access to their own. So that's easement. And encroachment is you have a permanent structure built on neighboring lands, but they are okay with it, or built on city property, city is okay with it. So sign agreement saying, even though you are encroaching onto my property, but I'm fine. I promise I'm not gonna sue you for that. I will not bring a court application to force you to remove that. So that's encroachment agreement. Yeah, so easement is more permanent, I think. Yeah, it's harder to discharge unless maybe the house is near, I don't know, near the ocean and then go like wash away or something, and then you don't need that anymore, maybe. Yeah, so the other permitting one is HOA fees, so nobody can discharge that. There's a homeowner association, they need to have all the owners pay them. And then zoning regulation, so those ones you can see, I think the houses near the airport or on the flight path, I think. So those related to airports, specifically designed to manage land adjacent to the airport or around. Yeah, because the most, I think, height restrictions. So those ones, I think if you are only helping client to buy or sell a single house, or it's safe. But if it's a commercial building, it's a high rise, then you might need to really pull this out, see where this building is. Is it too close to the airport? Is it too high up? If there's any danger, if the client want to redevelop. So it depends. But if it's a single house, I don't think you need to concern too much about it. You can still pull it out to look at. They just talk about this within how many meters the height of the building cannot over this, cannot over that, right? Because it's where the airplane taking off.
Also river, or
Yeah.
river, like,
Yeah.
because, if you are higher than
Yeah.
certain,
Yeah.
the fish,
Yeah.
yeah.
Oh,
You want to
okay.
protect the,
some fish habitats or something.
yeah.
Okay, yeah, so this one you can always pull out to take a look, but what I've seen most of this about the airport, I think, properties near the airport. Okay, development agreement is a legal document outlines specific conditions, obligations related to the development of that property. This one negotiated between the landowner and the local governments. So this is something commonly seen in the newer community, I think. Yeah, some of the developers, they sign agreement with the city and they can develop the property. But it's ongoing, it could last many years. But some of the older communities, the development agreement might be already expired. So in that situation, those agreements can be discharged. It might take a while, but we actually closed a deal recently. The seller's lawyer cannot discharge this herself because it's a part of the bigger project. The developer is working on discharge this agreement for the whole neighborhood. So yeah, it took us a while to actually get a comfort letter from the developer's lawyer saying, yeah, the seller's lawyer cannot give a promise, you'll give you undertaking to deal with this. But as a developer, we'll give you this letter confirming we're gonna discharge this eventually. So my client, we just have to advise the client, it's not risk-free because the thing is still on your title. And if the developer later decide not to do it, you still have to go to court. But because it's expired, so the court will be probably 99%, right? Allow discharge, but you're gonna have to deal with this legal proceeding. But client feels comfortable, so we close the deal. Because the developer gave a letter saying they will do it. So at that stage, it's all about negotiation and the risk management.
So long time ago, I remember, like, for
Yeah.
example, Hampton, I don't know if this belongs to
Yeah.
this.
Yeah.
They say your roof have to be tile or.
Oh, that's restricted covenant.
Okay,
Yes.
but no shingle.
Mm.
But I think after people
Yeah.
owned it, do they have freedom if they want shingle?
No, I think they normally say the first 20 years or something, or first 20
okay,
years.
that's why now
After that,
I
you can-
start seeing shingle roof
Different.
showing in
roofs.
Hampton. But
Yeah.
I remember before.
Yeah.
We're not allowed to put shingle roof.
Yeah, because within that
There's a-
restriction period, if you
Yes,
do it,
okay.
your neighbor can sue you, right? Say you breached this
Oh.
covenant.
But I think
Yeah.
if the first owner sell, the new owner not necessarily know this.
Yeah, see, that's what we were trying to say. If you not for closing, if just for the purpose of getting a clear title, you don't have to look at it because in the standard area contract, it says easement, covenants, those are okay. But the thing is, what your client actually wants, right? Maybe not only a house in this community, they also want to change the house to something they like. So the covenants might have some impact on that. So maybe take a look at that. If the client come to you saying, I want to buy a house here, but I have a plan to renovate in the next 2 years, right?
Mhm.
And then you might want to take a look at that. And then at least warn them, you might not be able to do it. Yeah. Okay. So the other one is a party wall agreement. So that's a document, for properties share a common wall or walls. Yeah, those townhouses or semi-detached homes. I think this is pretty common, so nobody can remove that as long as the two houses share the wall. And here, the non-permitted ones. So those probably more important because you want to tell your clients if this house is in trouble or not. Yeah, so those are the ones we call non-permitted. That means they have to be discharged, either before closing or after. Some they have to wait until after because the sellers, they need the money to discharge. So those are the ones, non-permitted mortgage, certificate of lease pendants, writ of enforcement, notice of security interest, some kind of court order, tax notification, and some just says caveats, and then they list certain things under that, says caveat, and then list either assignment of rents, promissory notes, lease interest, or buyer's interest, vendor's lien, builder's lien. So, but they all have this caveat first. Those are the ones non-permitted. But for caveats, I will talk about that a little bit later. Some they actually okay. And then here also a very brief definitions of each one, definition of each one. So mortgage is a legal agreement. Normally a bank or creditor lends money, and then they register mortgage. If the borrower doesn't pay, they can take the house. Certificate of lease pendants. Lease pendants is a Latin word for suit pending, means there's ongoing litigation about this house. So if you see that, you need to talk to the seller's realtor to find out what's going on. And then some of them can be discharged, right? Because maybe that's the whole reason they're selling the house, because they owe somebody money. Not somebody register lien suing them, right? They want the money so they can pay off their debts. It's not like you see it, then you can touch the house. It's not. It might be okay.
Do we put these in conditions?
This one, I guess, if they, how to say, so if they put on the market, so that most of the time means they want to use the sale proceeds to pay off something, to discharge that, right? Because it's their representations or warranties in the contract. Because the standard contract form saying the seller guarantees, promises, right? It will be a clear title. But if they have a lease pendants on it, means they have they owe some money. So means they will pay off the money. Otherwise, they breach the contract. So it's kind of like, which one is first? So they promise you they will deliver you a clear title, but currently they don't have a clear title because someone registered in, right? But the only way they can clear this title is get your money to pay off. So that's why even there is a ongoing litigation showing on title, but you can still see houses on the market because they need the house to pay off that. So if you see that, it's not necessarily bad. Just you need to probably ask the seller's realtor how much they owe, right? These pendants. You can ask them which kind of lawsuit is this, how much money involved. Is your client able to pay off the debt after I gave them my money to buy the house? So it's about amount. So this is something case by case, but most likely will be okay. Otherwise, they probably won't put on the market, right? If
So-
they can pay off, then they will have another lawsuit. The buyer gets sued.
Again, like we don't put this in condition.
If you
It's already
present
in
a
the
buyer,
contract.
yeah, it's a standard contract says that if you presenting a buyer, the best way is always ask for a copy of the title before you put an offer, or they are
Yeah.
really serious.
Yeah,
So
I
you
will.
don't need to put
yeah.
that in condition, but always
Yeah.
review the title.
Yeah, you don't need to put it as a condition because it's part of the seller's warranty. The seller said, I will deliver you a clear title. So this is already a condition. It's already there. It's only about like risk management. Just like someone promised you something and then that person break the promise. You need to make sure that the chance of breaking that promise is low. So that's why when you see that, you can tell the client there's a lawsuit, but probably that's the reason the seller is selling this house, right? They want to use the money to pay off. So once they pay off, that thing gonna be gone. So you don't need to worry about that. But meanwhile, you want to ask the seller's realtor how much money your client actually owe to the creditor, right? So make sure the house actually has enough equity to pay off that. And then you need to advise your client. It most likely will be okay, but there is a chance the closing might be delayed because what if the seller cannot settle the amount with the creditor? And then later realize, oh, I have an offer, but this money is not sufficient to give to the creditor. Or the creditor change their mind, want to ask for more. So there's some uncertainty. I will talk about a little bit that, I think before the end. Yeah, okay, so we can talk about this more later. Yeah, so rate of enforcement, that's a court order, allows a creditor to enforce a judgment. So this one is more serious. So this one pretty much means the seller doesn't pay this person registered rate of enforcement can sell this house. So this one, but this one's also easier to find out because there will be a court order, right? As a realtor, you can just ask the seller's realtor to show you the court order, how much. Or maybe you can pull that out. It probably just shows there. If the house is $500,000 and then there's a cash deal or the mortgage amount is not that much and the court order is only 20,000, then you're fine. The seller's lawyer will use that money to pay off that. So it's not a big concern if that's the case.
But are they allowed to sell it?
Yeah,
Because I remember before I couldn't put a listing, there's a caveat.
Yeah.
Then I cannot sell it.
you cannot sell
I
it.
cannot list it because there's a caveat. They have to pay the condo for first
Yeah.
before I can sell it. So if it, so my question is.
Yeah, I did see some outstanding condo fees, but those are the ones, but I don't know how those realtors manage to list the property. So it's at this closing stage. Because as a seller's lawyer, we need to provide condo, ISOBO certificate to the buyer showing this person doesn't owe condo fees, right? But the person actually owes. So we just have to, get money from the client to pay off that. Otherwise, the condo, they will not give us that certificate. So, but that stage is already it's an unconditional deal. So I don't know, is it, those realtors, they,
So my case is,
Yeah.
caveat, the condo for caveat, that condo.
Mhm.
So
Yeah.
we want to put it on the market,
Yeah.
I ask my seller pay
Yeah.
condo fee before I put it.
yeah.
Mhm.
I just mean, I saw some deals, they listed, they sold it, they
And-
remove conditions, so they deal with that at the closing stage. Because we need to get the,
So maybe
Condo
both
document.
realtor didn't check the land title.
I have no idea how they managed to, so is it like
Yeah.
internal rules or the realtor?
I think
Special rules
if
of for
there's a
realtors?
caveat, we will
Oh,
ask them pay out
Yeah.
before we can
this is
sell
your
it.
regulator set up their rules.
Yeah.
Oh, okay, yeah, so maybe some realtors need to follow the rules. Yeah, so we actually dealt with stuff like that, and then the condo, management just told us, your client owes us money. To tell them to pay now, we'll give you the certificate. So we'll just ask client to give us the money. Yeah. Okay. Continue notice of security interest. This is similar to mortgage. It's just a notice to everybody saying, there's a lender has security interest in this property. And then order, some they are permitted registrations. If it's a court order, talk about maybe rezoning, right? Or change nature of the land. Those are the things run with the land, we can really change. But some orders, they have to be discharged if it's related to seller's financial obligation. And builder's lien, this one is security interest. A builder or contractor can register against the property they have worked on to secure payments for their services. This one, it's quite common, like say someone wanna renovate the house and they're not very happy about the contractor's work, so they register a lien on it. So those are the things, if it's ongoing, you have to deal with. So builder's lien, if you've seen something like that, you probably wanna find out more. Yeah, because that's something also ongoing litigation. Just make sure the seller will disclose how much they owe the contractor and which stage it's at. Because some sellers, they really want to sell, they probably will pay security to court, and then they can discharge this lien. And the contractor and the original seller, they can still go to court to fight over this.
Question about builder's lien.
Yeah.
Any renovator, any builder can go and lien.
Pretty much, yeah. The law has definition of who can do it, so pretty much they
I
can.
heard
if
the
it's renovation
story
work.
about my customer, they
Yeah.
rent to a tenant.
Yeah.
A tenant do renovation at their
Yes.
house.
Yeah. Yeah.
Actually, they don't have agreement, but the
Mhm.
tenant go and lien the property because he say
Yes,
the
yeah.
landlord owe him money.
Yeah, but the landlord's liability is limited. I think it's it should be a holdback. It's a lien fund. I think it's a major lien fund, a minor lien fund. I think the owner has an obligation to hold 10% of the overall amount, the value of the work. So if something happens, if there's builder's lien, if the owner does things according to the law, the owner should have that 10% with the owner. The owner can pay in court to discharge the lien. But some people really don't know, they didn't get the money from the tenant, because the owner should get 10% as a holdback. Say, okay, you can do renovation, but in case you get trouble with the contractor, I want that lien fund. Here with me.
We do heard about, I
Yeah.
do see the news, right?
Mhm.
An
Yeah.
old lady doesn't know
Yeah.
her tenant
Yeah.
renovate her house and then be lien.
Yeah, so that's
that's
poor
allowed?
management. So the owner just had to force the tenant to pay in court, and then the tenant can still, have a legal battle with the contractor, but at least the lien can be discharged. As long as you have money to pay in court, you can discharge the lien. They can still sue each other, but then there's nothing gonna be on title. So, the owner just had to go pressure the tenant. Probably have to say, you breached the contract, and if you don't do it, I'll kick you out. So the tenant might just go do it, right? If tenant still wanna stay there. The same to commercial lease, the same thing. Some commercial tenants are gonna do the same. And the landlord, even facing more pressure because they have a commercial loan. So the lenders will not allow that kind of lien on title. So the landlord will force the tenant to deal with it. Otherwise, they can terminate the lease. Here, continue unpermitted registration, assignment for rents. It's agreement, the property owner assigned the rents from the property to a lender as additional security for that. So if you, your client buy a rental property, most likely the lawyer closing the deal will register assignment for rents for the bank because it's a rental property. So the bank has actual security that if the client doesn't pay mortgage, they can collect rents from the client's tenants. Those ones, you don't have to worry too much. Assignment for rents, if this one is with mortgage. So if your clients sell the house and you get the sale proceeds, if you can pay off the mortgage, assignment of rents will be automatically discharged. So you don't have to worry about that one. Promissory note, it's kind of similar to mortgage. It's just someone borrows money from a person, the person register a caveat showing this person will be money. It's similar to mortgage, so equally important, this one.
So if promise note.
Yeah.
Both parties sign without lawyer, is that
Mhm.
still treated as legal document?
Any contract, as long as meet certain legal tests, like, two minds meet, they agree on the same terms and the terms certain enough to perform and there's consideration, it's a binding contract. So you don't need a lawyer to make a contract effective. Only if it's too uncertain, nobody can interpret it what actually the both parties agreed on, then maybe it's not. Tax notification, we already mentioned that, so just make sure your client gonna pay property taxes, make sure the seller will pay property taxes after closing the deal. So as long as the seller's lawyer can provide the undertaking, say, to the buyer's lawyer, say, my client doesn't have the money to pay off all those debts, but if you give me your client's money, I will use that money to pay off everything, then it's okay. But the early stage, what you can do, I guess, is just to tell the client what is this about and how much money is there. And likely if it's less than the sale, the sale price, it's okay, right? But then just can't guarantee them. Just say it likely be okay because they promise they will give you a clear title. So the seller probably owes less money than the sale price. But this is always something out of the realtor's control, right? Because nobody can prevent someone to breach the contract. So later, if the seller does something wrong, if you represent the buyer, just make sure manage them, right? So they will not blame you. It's not your fault. Yeah, as long as you give them all the information. And unpermitted, sorry. Why is not moving?
Page up, page down.
Oh, okay.
Oh, yeah, against the button.
Oh, you see here?
Yeah.
Oh, okay. Yes, okay. So continue, lease interest. So this one, sometimes it's permitted, sometimes it's not. it depends on if the buyer wanna assume the lease, right? So this one we mentioned before, and then buyer's interest. So this one refers to interest a buyer of a property has that may be pending completion of certain conditions. Yeah, so this one is just, yeah, someone already put an offer on the house, but for some reason they haven't finished the closing. But the buyer doesn't want the seller to sell the house to someone else. And the seller agreed the buyer can register a document showing, yeah, this house already, sold to this person, but just hasn't finished the deal yet. Those are all temporary registrations. But if you get a new deal, it shows that you probably cannot buy that. Just don't tell your client to
Is
buy
that
it.
normally
right?
happen in commercial, like tenant has right to purchase?
Residential, I see something typical is the seller, for some reason, the buyer didn't maybe do something, and then the seller find an opportunity to change their mind, say, I'm not gonna sell to you. I'll give you the deposit, give you back, deals off. Then the buyers really want that property and doesn't think she or he did anything wrong.
So they
Yeah,
can go
they
and
can go ahead,
register.
register something
Oh,
like that, and then the seller wanna sell to someone else, and then we have to deal with that first. I actually have some deals like that.
How
Yeah.
about like
Mhm.
this year is always competing offer?
Yeah.
Can the buyer say, I give you full price, no condition, you have to sell to me and I go, or otherwise I go register something?
No, this only okay if they already signed the offer, both parties
Okay.
signed the offer. But for some reason, the seller changed their
Changed
mind,
mind,
maybe
okay.
saying, as a buyer, you're supposed to do something, you're supposed to give me deposit, but you didn't, right? The deal's off. But then the buyer said, oh, there's a reason I didn't give you, maybe, the person delivered the money got hit by a bus. So I still you should still sell to me. And then the
Okay.
buyer is angry, and the buyer, yeah, so that will actually happen to one of my clients. The buyer's father registered this buyer's
Oh.
interest, so we had to write some kind of a demand letter. Yeah, so eventually they backed off, they discharged that buyer's interest, otherwise the new buyer cannot put offer on. Yeah, so that's buyer's interest, and then vendor's lien. Vendor's lien commonly seen in commercial ones, because commercial deals sometimes take longer to close. You already gave the money to the seller's lawyer, but because the rules, the seller's lawyer hasn't given the money to the seller yet, but the seller already provide title, transfer documents. In that situation, vendors just say, okay, I'll put a lien, once I get the money, I'll discharge the lien. So this one also has to be in the purchase contract, which says the vendor has the right to do it,
Mhm.
and the vendor might do
Does
it.
that happen to the new home, like if the delay position?
Could be, as long as,
Yeah.
yeah, it could happen, so
We
it,
need to transfer back title and transfer it.
yes,
That-
because I think the standard contract used to have that. Just say, because commonly people close deals conventionally.
Mhm.
You gave the money to the buyer's lawyer, the lawyer go to transfer title. And, but only, the seller can only get the money when the title is transferred to the buyer. So before that, the seller doesn't have the money. So that was commonly used in the past, but now because more and more we use title insurance or the protocol lawyer closing. So I think the area probably changed that term, so that's not in the residential ones. But for commercial contract, I think it's still there. But some people, they don't want the vendor to register anything, so they just cross it out. Yeah, so that term still in the commercial one, I think.
If the vendors take back, also vendors lien?
No, but vendor take back is similar to mortgage. Vendor take back is mortgage, like the lender lend money to the buyer. If the buyer doesn't pay back, the lender can take the property back, but as a mortgagee, as a lender, not as a vendor. Vendor's lien is about, as a vendor, I haven't received my money yet. Until I get my money, I'll register lien. Okay, so caveats. So those are the things we commonly see unpermitted, and caveats, some permitted, some unpermitted. I just want to quickly talk about what a caveat is. A caveat is a formal notice or warning filed. It's kind of like a notice, warning, just say, warning, there's some problem with this property, don't buy it. It's kind of like that. Yeah, so there are different types. So I listed some of the common ones. So some financial claims, like a promissory note. So you can put a caveat, promissory note, just saying, you have to know, this person borrow money from me, and then if that person doesn't pay me, I'm gonna sue, and then I'll put this house on the market. So that's financial claims.
So it doesn't matter how much, right? Because I saw one
Yeah.
title has lots of caveat, even like a
$1,000.
secretary didn't give a pay salary for 2,000.
Yeah, doesn't matter the amount. I'm telling you, so. Yeah, it doesn't matter how much. Yeah, they can do it. Yeah. Yeah, so the second one, it's less common. Yeah, just that someone has some legal rights to the property, and they don't want people to know what exactly they have, but they want people to know you can't just simply get this house without my involvement or my consent. So they can also register. So the example is a trust. If there's a real owner.
Question, is that caveat very easy to do? Can we say, I just borrow money from him?
Yeah.
He didn't.
Caveat, you need the owner's consent. So when you register, you need the owner's consent. Let's say lease interest, right? So the landlord, let's say commercial lease, the landlord will say, okay, we'll sign a 5-year lease. You allowed to register a lease interest on my title. Then, so the tenant can be protected because the public will know the tenant actually has control of this piece of land for 5 years. Yeah, so only the landlord agrees. If the landlord doesn't agree, you can't register that. Yeah, just also like assignment for rents. The more the bank want to register that, the owner need to agree.
So when I see
why
the
register?
staff, like secretary salary, that's also, they agree?
No, that one probably is a
Foreclosure, yeah.
enforcement or something.
Oh, okay.
Yeah,
Yeah, so
because this,
caveat for the
yeah.
condominium company corporation, do they have the rights to put the key? To sell it?
condos,
Yeah, condo corporation.
I think so.
Condo
I think
is
they probably,
like-
yeah.
Yes, they do.
it's
100
allowed
bucks.
by law.
100 bucks, my
Yeah.
client be caveat.
Uh-huh.
They
Yeah.
didn't pay,
So-
they didn't receive the notice to pay the
Yeah.
entrance key.
Yeah. Right.
So the builder's
one.
loan will be showing up on the title as the form, as the definition of a caveat. So it
Yeah.
doesn't really show the
Mhm.
details, but it
Yeah.
will be a registered caveat with a
Mhm.
registered number.
Yeah.
And you go to pull the details from
Yeah.
that registered number.
Yeah, some even you put out, there's still not enough information, then you have to contact that person on title to ask them what it is about.
Yeah, they normally
can we
show
deal
as
with
a
that?
registered agent.
Yeah, you have to contact that person. Okay. Yeah, so caveats, there's certain ones, also is easements, rights of way. So those are the ones similar to the ones we talked about. And this one is the family property issue, it's lease pendants. They also put it under caveat. So some they register, it depends on the land title requirements. So when you see a caveat, sometimes bad, sometimes okay. If under caveat shows easement, rights of way, that's still permitted. But if under caveat, like you said, if I put some condominium owning the money or these pendants or rate of enforcement, then it's not okay. It's unpermitted.
So this one, for this caveat, if they have, let's see that it's the condo board registered on title because the owing
Yeah.
condo fees.
Yeah.
And when my client or seller paid
Yeah.
off
Yeah.
to the lawyer firm, they give the details.
Yeah.
So that caveat,
Mhm.
who's gonna request to remove it,
It
discharges?
should be the who registered it.
Or
So the
once they
condo
get
management
receive
company?
the.
Yeah, once they receive the money, they should go discharge. Either they go discharge or they provide you the discharge document.
Or to the mortgage payment.
The client's lawyer, right? Either they go discharge themselves
So
and
there,
provide a proof.
so as
or-
a listing realtor, we should ask for a discharge certificate.
If it's like you said, if they have to do it before the closing process,
Yeah.
they have to give to the
My
client.
case,
They give to the client.
to the bank, because the bank send the letter.
Yeah.
The mortgage.
But the discharge document itself, they have to give to the
To the
client.
property owner.
Yeah, give to the client. Either they have to do it or they give to the property owner. The property owner can go to land titles to discharge it. Yeah. Okay, so here, yeah, so those are the things I said, what you do when certain registrations on title. So the first one, we already covered, I think, most of it, registrative covenants, which is say when the house was built, oh, this one, a little bit different. So this one, when the house was rebuilt after the registration, you can see some really old ones, registration 1994, 100 years ago. And then the house actually was demolished and rebuilt maybe multiple times already, but the registration is still there. So if you pull that out, if there's some specific requirements, setback requirements, or you're not allowed to build a second kitchen or something, and then the owner after didn't know and built a house, very apparently violating the covenants. You cannot really, don't buy it, right? Because the neighbors can sue this property owner. So when those ones that happened to my clients, so I always just suggest the realtor maybe to go do some due diligence. So if it's a setback requirement, so any new house built on the property, it has to have like a 20 meters distance from the property line, right? Maybe you measure that, see if it's, yeah, see if the new built one is actually, over 20 meters and make sure of compliance. So those are the ones I think you need to pay attention. So I just put here setback requirements. Yeah, that was a real example. Very common, I think, for the setback requirements one. And this one is a family law certificate for lease pendants. This just means there is ongoing divorce or family property division claim. And that might be the reason they're selling the house, right? So for
He has customer asking, so
Yeah.
when he hear divorce.
yes, yeah. So that's a headache, but at the same time it's an opportunity, right? That could be a good deal for your client. They want quick close and they will lower the price. So always warn your client about the possibility of delay in the closing process, because after they agree to sell and before closing, there's still probably could be months, and negotiation could just fall apart or one party change their mind. So there's some uncertainty. So that's why I recommend some kind of additional terms, even though the standard contract already cover almost everything, like a delay, who breached the contract, under what the buyer or the seller can terminate the contract. But still, there always something not black and white. But if you deal with a property with a divorce problem, you might want to, there's a additional term, right? Section, is this 9? I think paragraph 9, like additional terms.
9.2.
Right, additional terms. You can consider to add something if the seller unable to complete, within certain days, and then the buyer maybe can get compensation, or the buyer can just terminate. Just make it more specific, because the law only says time is of essence. But can you actually terminate the contract on the closing day, like at noon, if the buyer doesn't give you the money? Probably not, because there's also a contract principle called a good faith. So if the buyer did everything she could, and there's something else he could, and something happened, they're delay, like 3 hours delay, half day delay. Can the seller really terminate the contract? Maybe not. It's up to the interpretation. The court gonna decide. But if you want to avoid that kind of uncertainty, and you deal with the property potentially with some kind of a delay possibility, maybe add a term. Let's say this one, we probably, well, if you cannot close on the closing day, the buyer has the right to extend, but the buyer can also terminate. So make it more clear. That will make the client feel more comfortable.
It happened to me
Yeah.
like the day before possession, one of the party passed
Yeah.
away.
Yeah.
Wife. Yeah.
Okay. Then they have to deal with the
Yeah.
for a grant for administration, and they have to name a personal representative. But still, the surrogate court dealing with the people dying, they can have a special channel. They can deal with those quickly, because if a house, there's a closing day, they can do a quick decision. The court can say, I can't finish the whole process, but just for the house, I will name a executor. The executor can continue the process. So but it's actual work, yes.
And
But that's
also
unfortunate.
another case is the day before possession, the whole
Yeah.
house in the
Burn.
water.
Oh, no. Oh, that happened, yeah, to some of my clients. Yeah, and then
Burns.
they delayed for almost half year. Yeah, it was a condo, so they have to fix the whole thing.
Yeah,
Yeah.
just a quick question, because regarding,
Mhm.
we always have a final walkthrough one day before the closing day, right?
Yeah, yeah.
During the final walkthrough, everything's fine.
Mhm.
But on the closing day,
Yeah.
after 12 o'clock, everything closes.
Mhm.
Then go to the house.
Yeah.
There's a damage.
Yeah.
In the house that wasn't,
Yeah.
there during
Yeah.
the final walkthrough. Is there anything to be done?
Mhm.
But or
Mhm.
if past 12 o'clock.
Yeah.
Everything closed,
Mhm.
there's nothing to be done.
Yeah. So that one, you just have to look at the contract terms, because I think it's a paragraph 2.4 or something, just says the property has to be substantially the same on the closing day. So
Yeah.
you just see if you actually have an argument on that, because substitution, if it's just like scratch, if they move out, probably there's no case, it's hard.
Or
Yeah.
if it's dirty.
Yeah.
Not clean.
But if they're garbage, because if they promise a vacant possession, right? If they have a half garage still full of garbage, yeah, you can still continue, yeah, the argument and contact the seller's lawyer. Yeah.
But the thing is, the lawyer already closed the fund.
Oh, that doesn't matter. I had
Doesn't
a file, the seller's lawyer didn't tell us something, and later the buyer find out and told us. So we told the lawyer, hey, your client didn't do this. And then the lawyer said, oh, too bad, the deal is closed. Then we just said, well, you know what? You as the seller's lawyer, you have obligation to advise your client certain things. So your client was lying about that. Now you also on the hook. You have to tell your client to deal with this. Otherwise, we're gonna sue the client and then you. So the lawyer kind of was on the hook. So the lawyer eventually said, okay, I'll go talk to the client. So probably the lawyer told the client, you have to give buyer that, otherwise the buyer gonna sue you. Yeah, so we got the money still.
Even
after
if you
closing.
close,
Yeah.
they still under the contract terms, they
Yeah.
still have obligation to
Yeah.
deal with whatever
Yeah.
after. It could be go up
Yeah.
to even to few years later.
Limitation is 2 years. Like when you know or you should have known the damage from that day, 2 years, right? Yeah.
Okay.
So because the standard contract, they have a term just saying, it's called a merger, it's a legal term. Without the term, normally just say if you close the deal, means you agree to everything is fine, the deal is done. But if you have a specific term saying, no, there's no merger, if there's something wrong, your warranties, your representation survive the closing, then I can still go after you. So that there's a term in the standard one, so your client can still go after them.
Yeah.
Never harm, there's no harm, never don't fear to ask, just contact the client's lawyer, right? See what the
Yeah,
lawyer can do.
it is a little bit different.
Yeah.
Just like the great pipe, the poly B version.
Yeah.
Before the final walkthrough, everything's fine.
Mhm.
Client move in,
Mhm.
you turn on the water, suddenly.
Yeah.
Something happened.
Yeah.
Now,
No
Yeah.
harm to ask.
I
You
know
can still
that-
go back, ask them to say something wrong, right?
Yeah.
Yeah. Some people, maybe it was just accident, maybe they're nice people, right? They feel bad, it's okay, I'll come back.
So after.
Yeah.
Position.
Yeah, so basically during the final walkthrough, we check whether everything's fine.
Yeah.
It's fine, but then after the client moving, after a week.
Yeah.
The ceiling starts to leak.
After a week, it's hard.
Yeah, I know,
Yeah,
so-
the seller gonna say you broke
Only
on the
that
same day, a night
same day, yeah.
Yeah.
But my case is, I've sold one property, my case is after the buyer moved in about 2 or 3 months.
Oh,
It was a
that's long.
heavy rain season. We have that rain season happening, that they did inspection, they couldn't find anything. That's unfinished basement,
Mhm.
they have water in the basement.
Mhm.
And after whatever
Yeah.
they use, they find a crack.
Yeah.
Which they didn't discover during the whole inspection.
Yeah.
This was closed.
Yeah.
Few months later.
Yeah.
So the
So-
buyer's lawyer
Yeah.
write an email or
Yeah.
to the contact our seller's lawyer, they still have to deal with it.
Yeah,
Doesn't
so-
matter if
So
it's
if they can
closed.
prove the seller purposely, hid
Yeah.
that information, it's latent defect. Yeah, it is, that's
So,
a
yeah,
legal
doesn't
dispute
matter.
right there.
It's-
The
it's
seller
still
will
have
be
to
still
do it.
responsible. Yeah. Okay, so I just gave an example, like if there is a lease pendants registered on title about a family property dispute or divorce, you can add something like that. I'm not saying you have to add this, I just say for example, I just give example, just say you can put say seller and unable to complete before closing day, the seller need to, notify the buyer the reasons, right? And then compensation, if the buyer suffers some loss, the buyer can ask for compensation. And then also right of termination, the buyer can grant some extension, but if it's over 5 days, over a week, the buyer just gonna walk away from the deal. So just put a little bit more specific terms to protect your clients. Okay. Also, this one I just gave an example. This is actually just happened this year, January 29th. I had a client also with my friends. She wanted to buy this beautiful acreage in Rockville County. Yeah, there is a lease pendants registered. So she actually, before she put an offer, she called me up because we're friends. So she called me up and I saw that. So I told her, I said, normally you get a good deal because they want a quick sale, but there's uncertainty. The biggest risk for you is delay because you don't know what's going on with those two parties. And then the client really liked it. So she put an offer on and then, yeah, closing date January the 29th. And oh, I don't know what happened here. So maybe. So this is continue, I guess. Yeah, so, and so the client actually, because I told her, so she kind of was prepared. And then on the closing day, the seller's lawyer couldn't provide undertaking to discharge that lease pendants. And then she told us because the husband wasn't happy with the arrangement in the family law dispute. So so we gave them a lot of pressure. We wrote letters just saying your client's in breach, we're gonna sue you and those things. And then eventually the husband finally agreed to sign the documents. And then we closed the deal on February the 5th. And then we also got some compensation from the seller because my client did a few things based on the closing date. So they paid some of the money to my client. But still, the client was pretty anxious, after January the 29th, that's the closing date. So she kind of couldn't sleep well for like the whole week, right? Yeah, but because I told her that before she put an offer on, so at least she knows that something could happen. Then as a realtor, if you tell the client that, at least they will not blame you, right? Then they go, okay, I know that that was my own decision. Yeah, so put some pressure off. Because I know a lot of realtors have a lot of pressure because the clients, yeah. So if you manage them a bit in the beginning, right? So the work will a little bit easier later on. Yeah. Okay. So what to do? And then if you see a title, there are multiple mortgages or security interests or tax notifications on title, maybe reasonable, like I said, reasonable inquiry on the seller's ability to pay off all those loans. Just warn the clients if the sale proceeds are not sufficient to pay, they can close the deal, right? So just those are things. Because even say the client will not suffer any loss, but think about the effort you made to put an offer code, right? Try to close the deal, but then later the deal's off. Yeah, so so this one, let me see. Oh yeah, this is the one we talked about. Someone buys some property, but with some specific purpose, and then there's a restrictive covenants. They're not allowed to do certain things. You probably want to take a look. But sometimes, like you said, the market is really hot, and you can't really do a lot of due diligence before you put an offer. Maybe just put a condition. Just say the last one. Just some example wording. Just say it's conditional upon maybe the buyer's solicitor or lawyer looking at the title, right? And then make sure this is the property the client wants. Not only legal risk about debts cannot be paid off, also if this is the property the client actually want to buy, right? If they want to renovate or they want some beautiful backyard, and then later they find out they're not allowed to build anything there. So those are the things. If in a rush, you can always consider to put a condition. Say the lawyer will look at the title later and see, and then you can waive the condition later, right? At least you can put
So you
offer on.
mean even it's no condition offer?
No, just like say, because if some people, if you don't make them comfortable about the title, they might not even want to put an offer on,
Yeah.
right? But at least this way, you can put an offer, but it's still conditional. The lawyer need to look at the title, right? Yeah. I mean, yeah, it's not as good as non-conditional, but it just control the risk. But at the same time, you already, at least you have an offer there, right? Yeah. Yeah, so I think that those are the things I I put in the PPT, so if you have any questions, we can also, yeah, have a quick discussion. If not, you can always call me or email me later. I have my phone number here. And then, yeah, so later.
So most of the time, we still don't, I still tell customer because
Yeah.
land title change, all the debt or all the KVN
Mhm.
won't go to next buyer. You will clear the title and then transfer. So I mean, if previous owner got lots
Yeah.
of lien or
Yeah.
KVN,
Yes, yes.
it won't transfer to next
No.
buyer.
yeah, because
Yeah.
in the standard area contract, it
Mhm.
says the seller need to deliver a clear title.
Yes.
And then the definition of a clear title is in the paragraph 5, right?
Yeah.
Only those ones implied by law or non-financial ones will remain. So you can tell the clients, if they only worry about clear title,
Mhm.
that's not a concern, those ones. And those
Yes.
ones, they are financial obligations, but yeah, the lawyers will use the money to pay off.
So should we let them know?
Yeah.
Be careful, the land title is lots of KVN, lots of lawsuit, because I think that make
Yeah.
them nervous.
Did that belong to the previous owner?
So that's why I think the stage, like a realtor putting offer, just the last few slides, I just suggest, number one, if you see lease pendants, right, or
Okay.
builder's lien, something kind of like a
Maybe timing issue, delay.
Yeah,
issue,
so those
yeah.
ones, because there's bigger uncertainty, because that means ongoing litigation.
Mhm.
So, but that also means the seller probably really motivated to sell because they need the money to get rid of the disputes. But those ones, family law disputes and the builder's lien, those are ongoing because we don't have a result. So those are the ones, yeah, you can tell the clients, mostly it will be okay because the seller already promised to deliver clear title. So
Right.
the reason they sell is they want the money to pay off those.
So if it's go to foreclosure.
Yeah.
Well, we say safe for buyer because it's court and.
Foreclosure, I think the only danger is ISIS, sometimes angry people go back to the house and trash.
Oh, yeah, I got one case.
The house in yeah,
That woman
yeah. Oh, actually.
has mental
Mental
issue.
issues.
Yeah,
Yeah.
and she went back and the
Yeah.
neighbor told my client say.
Yeah.
She did dig a tunnel
Oh, I
to the
see.
neighbor.
Yeah, because the court ordered transfer will only promise a clear title, but will
Yes.
not promise the condition of the property. So that's the risk for foreclosure properties. Yeah.
I think for
Yeah.
foreclosure, they only promise as long as there's a structure on the land.
Yeah.
But they don't guarantee any condition. on
Yes,
because-
yeah, they only promise the title will be clear. They will discharge whatever all the financial obligations on title.
So
Yeah.
if the previous owner come back, we just call police, right?
Yeah, this is trespassing. I guess you just have to call the police.
So what happened if the house burned down? By the
Call
Well,
insurance
the
company.
insurance.
Yeah.
I mean, the contract, you need to look at the contract or the court order saying when the risk will
Agree.
shift to your client. Normally it's when you give the money to the other side. So for the standard contract, area using, it says once the purchase money goes to the seller, the risk go to the buyer. So that's why I always tell my clients in the office, the seller clients, the closing might be delayed. Make sure you still have insurance because without the buyer's money, the risk is still on you.
And that's why don't
Yes.
release key. Don't release key before
Yeah.
lawyers say okay to release because.
Yeah.
Yeah,
Yeah.
the
insurance issue.
responsibility
Yes.
is still on seller.
Yeah, so the risk only shift to the other side when the money actually transferred, not the closing, not the title transfer, those things, the money. Yeah, if you look at the contract, Yeah.
So in
Yes.
simply say like during the close day of foreclosure, I'm
Yeah.
just gonna stay at the house. I'm looking to make sure
Yeah.
everything completes.
Yeah, we
Yeah.
did, actually, we saw the move where we did be there at 12 o'clock, right after the key release, they're
Yeah.
still moving. So
Yeah.
my client is sitting, we're just watching,
Yeah.
okay, until
Yeah.
2 o'clock, they finish all the moving.
yeah, those
So
ones you
until
can
they
contact the
go.
lawyer, we're gonna ask them to pay some money, that's because you promised to deliver a vacant possession by noon, your client's in breach.
But they're still moving, what you can say, right?
Oh,
Illegally,
ask
the
them-
money is transferred, but they're just slowly getting things loaded and slowly
Oh,
clean up.
But the lawyer getting the money to the client getting the money, there's still, a little bit time, so you can always contact the lawyer. The lawyer can send a letter to the seller's lawyer to say, your client breached the contract, the house is not vacant. Yeah, pay
No,
some
that's a
money.
foreclosure. The
Foreclosure.
seller is
Oh.
a court, so they
Yeah,
don't care.
but if
nobody
you,
cares.
yeah, then that case, you probably just tell your client, you got a really good deal on the price, so wait a bit then. Yeah, it's a different.
Question about dowry right.
Mm.
So is dowry rights only the right, not the money dollar amount, right?
Dowry rights, yeah, it's one is, that person can live there until she or he dies. The other one is, the owner cannot sell or refinance or sign a over 3 years lease without the spouse consent.
3 years lease.
Yeah, or 3 years long-term lease, or
Right.
refinance or sell without the spouse consent. And if the owner, forged documents, swear false affidavit saying I'm not married, right? To sell the house, then the spouse entitled to half of the purchase, the sale price, the proceeds. Yeah, so the spouse actually has right to compensation.
I heard about a case is the husband as a lawyer registers on title.
Yeah.
Say the other party has no dowry right. Can that happen?
It's called a dowry release, but the other party need to sign that though, with a lawyer, with an independent legal advice.
Then
Yeah, so
Yeah.
because some parties, they wanna get a divorce, but take time, but they already agree on property. So the
Mhm.
husband will gets the money, gets the property, the husband wanna sell, but they still married. And then the wife
Dowry
can
release.
sign a dowry release
I
and
think that
register on
case
title.
is like one party thinks it's all his money, and the other party has no money, and he wants to sign dowry release before they purchase. They're still together, but they are not like
But then if there is an independent legal advice, everybody has the freedom to give up your legal rights. But without a lawyer, yeah, that person can challenge, say, I
Yeah.
don't know that, right? Nobody told me. So I changed my mind. Yeah, so that's
so they can still change mind, say.
if the agreement is enforceable, the court has a final say if it's enforceable or not. Yeah, so for dowry rights actually related to today, sometimes you can see it says dowry release on title. So if you see that on title, you don't need to worry. It just means the seller doesn't need the spouse consent. And then once you close the deal, that registration will be just off the title automatically.
Because before at CIR, another
Yeah.
lawyer always like to use the example for
Yeah,
go to Las Vegas, marry one day, and
Yeah.
then the other party get a 50% right.
I probably, that might be in certain kind of context. Yeah, because it's not in this province.
Okay.
Yeah, so,
That's
yeah.
US, not
Yeah,
here.
it's as a joke, like with some kind of context, maybe.
So
Yeah.
it's not like the person leave over, stay one night, then she got the right.
Dowry rights?
Yeah,
Yes.
they
Dowry
marry
right, yes, leave, because
one night.
if this is a family home, right? Either of them ever stayed in this house, the other person, yeah, can live there as spouse.
Okay.
Yeah, but only leave,
Mhm.
not 50% only happens, the husband sells without that person's consent. Yeah,
Okay.
the Dowry Act
Oh.
says that person entitled to 50%.
Okay.
Yeah, maybe that's what he meant.
Mhm.
Yes. Yeah, but if he doesn't sell, yeah, the wife just has a right to live there.
Okay.
Yeah, and then if they get a divorce, the wife doesn't get the property. It's an exempt property before marriage. Yeah, so maybe, yeah.
Thank you,
I mean,
thank you for
oh,
your time.
welcome. Yeah, my pleasure. So if, yeah, you have any questions, you can call me or email me later.
Catherine, I have a last question.
Oh,
One.
yeah, there, I
Question
forgot about
online.
online friends.
Yeah.
Yeah, I already raised my hand for a while. So, okay, what's your opinion about to suggest the buyer to buy title insurance? And what's the percentage as your law firm to deal with all the transactions? How many buyers bought their
Yeah, so for title insurance, my personal opinion, I think it's a very good way to protect your clients, because title insurance is a one-time purchase. And if it's a property around $500,000, the insurance is only $200-300, and it's a one-time payment until the client sells the property. And then the title insurance can protect a lot clients from a lot of the risks, like a mortgage fraud, or some city orders, like say the seller violated some city bylaws and the city issued an order. The seller didn't tell the buyer that, and then later the buyer had to fix the problem. Could cost thousands of dollars, maybe 20, 30,000. The insurance can cover, right? So I always recommend clients to buy title insurance. But I know some of lawyers outside of the Chinese community, they directly just order that without even asking the clients. And then when the clients come to the office, they tell the clients, I already bought this for you because this is good for you. And then very few clients refuse because they think, oh yeah, that's actually good for me, small cost. But for Chinese clients, I'm not saying clients is not, but more, I think sensitive to numbers because they want to know what they actually spend on, right? So I normally don't order that without client's consent. But I always send them an email including all the information, including title insurance. Tell them why title insurance is really a good thing. So if the clients read the materials and then want us to order, we'll order. And second one is during the signing meeting, I also recommend clients if the client, number one, is a cash deal. Number two, they don't have RPR. Those are the ones. Or the RPR is super old. So those people, I spend a bit more time to stress the importance of a title
Can
insurance.
foreclosure property do title insurance they can buy? Foreclosure?
Yes,
Okay.
Yeah. Maybe, the title insurance might ask more questions. And then if the risk is too high, they might just say, I can't, insure this part, but this part I can do.
Or can owner purchase title insurance after they own the property?
It's hard. Yeah, only when they do refinance, the insurance company will agree to insure the lender, the mortgagee, not the borrower, the owner. Yeah, so ideally just buy before you close the deal. As an innocent party, you protect yourself. Yeah, so for my clients, I think, let's say if the ones, like I said, a cash deal, without property, without RPR, with a super old RPR, those clients, after we explain to them, I think 80% they will buy. For other clients, maybe say 30%, if I didn't try a little bit harder to convince them, because we send the information in our first email to clients. Yeah, but some people, after they read it, they ask us questions. So those clients, likely they're gonna buy because they feel that's something important. Yeah. Okay. Hopefully I answered your question.
Thank you so much.
Thank you.
Thank you.
You're welcome.
For your time.
Yeah, maybe we can just have a session just like common questions or issues.
Yeah.
Yeah, but this one is more focused on like the
The
foundation is very
Quite
important.
deep. Yeah.
Okay.
谢谢。Thank you.
Welcome.
So much.
Welcome. Yeah. So Vivian, you already have the materials.
Okay.
Yeah, I'm okay. You guys
Sure.
share because it's
Sure to
yeah.